124A. Sedition. Whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in with India, shall be punished imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Explanation 1. The expression, disaffection, includes disloyalty and all feelings of enmity. Explanation 2. Comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means, without exciting or attempting to excite hatred, contempt or disaffection, do not constitute an offense under this section. Explanation 3. Comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection, do not constitute an offense under this section.
Years in existence. IPC Section 124A, also called the Sedition Law, was put on hold by the Supreme Court on May 11, 2022. Here is a quick timeline of what happened in the past. In 1860, IPC in Colonial India. In 1837, IPC was drafted by Thomas Macaulay and brought into force in Colonial India in 1860. It had no section concerning sedition, but through Clause 113 of the draft IPC, he introduced sedition as an offence punishable with life imprisonment. However, it is argued that the clause on sedition was dropped from the original IPC draft by mistake. 1870. Addition of Section 124A. James Stephen, a British politician and lawyer, introduced Section 124A, also called the Sedition Law, in the colonial IPC. The British rulers used the law to muzzle demands for freedom. Bal Gangadhar Tilak was the first person convicted under sedition law for his speeches at the Shivaji festival. 1922. Gandhi's conviction. Mohandas Karamchand Gandhi was charged with sedition due to his politically sensitive articles in Young India. Gandhi pleaded guilty and was convicted and sentenced to 6 years in jail, but was later released after 2 years on medical grounds. 1942. Federal Court definition. The Federal Court of India defined sedition law as public disorder, a reasonable anticipation or likelihood of public disorder. 1949. Sedition dropped. After rounds of arguments, sedition was no longer a part of the Indian Constitution adopted on November 26 as grounds for reasonable restrictions of fundamental freedoms. However, Section 124A remains in IPC. 1951. Nehru's Amendment. The Nehru government brought the first amendment under Article 19(1)(a) and puts reasonable restrictions on the right to free speech. 1974. Cognizable Offense. The Indira Gandhi government made Section 124A a cognizable offense that authorizes police to make arrests without a warrant. 2021. Challenging the law. The sedition law was challenged by various representatives and a notice was issued by SC asking for reply from the central government. 2022. Supreme Court's decision. Supreme Court declares to hold a final hearing on pleas and the centre was given time to clear its stand on scrapping the law. The 9th of May 2022. केंद्र का समझौता. केंद्र ने सुप्रीम कोर्ट को बताया कि उन्होंने आईपीसी की धारा 124A के प्रावधानों की फिर से जांच करने और उन पर फिर से विचार करने का फैसला किया है. May 11, 2022. Sedition law on hold. Supreme Court allows the centre to rethink and re-examine Section 124A. Till the reconsideration, no new cases under Section 124A will be registered. Those currently jailed under the law can apply for bail. Landmark cases. Queen Empress vs. Jogendra Chandra Bose and Oz. The first sedition case of India was heard in 1891 at the Calcutta High Court. The proprietor, manager, printer and editor of the Bengali magazine Bangobasi are tried for sedition as they had criticized the British government for raising the age of consent for sexual intercourse. Kedarnath vs. the State of Bihar in 1962. A 7-judge bench of the SC upholds the constitutional validity of Section 124A. Justice B.P. Sinha clarifies that unless there is incitement or call for violence, it does not fall under sedition. But it does not provide who decides if there is an incitement to violence or not. Balwant Singh versus the State of Punjab in 1995. Balwant Singh is accused of raising incendiary slogans of Khalistan, Zindabad, after the assassination of PM Indira Gandhi. SC acquits Singh, stating that casually raising slogans without any violence resulting from them does not amount to sedition.